Which camera is on? It's glitching yet.
I think
Yes.
I mean in this context.
All rise.
Section. Before you begin, I'd just like to remind you again to introduce what you'll be talking about, introduce the speaker, and give us, the time that you've been allocated or the time that you'd like to take. And yeah.
As the court pleases, I would like to ask the court if I'm audible enough. If the Honorable Justice can hear me.
Pardon?
Oh, okay. No, I wanted to ask if you could hear me.
Yes, could you, please try to project.
Yes, I'm going to try. Thank you.
Difficult to project, which we will. Please try to project. Thank you.
May it please the court. My name is Ntloso Malwana. I appear on behalf of the respondents in this matter, together with my co-counsels, Rebuttal and Nkosi Mnyamana. Honorable Justices, with the court's discretion, we will take 10 minutes each to address our issues. I, Ntloso Malwana, will address issue A regarding standing. Sorry, apologies, Honorable Justice. I'll address issue A regarding joinder. My co-counsel, Rebuttal, will address this court on issue B regarding standing. And my last co-counsel, Nkosi Mnyamana, will address the court regarding the exhaustion of internal remedies. With the court's permission, I would now like to begin with my submissions. As the court pleases. Honorable Justices, this matter is not merely a policy disagreement. It is a question of legal process and constitutional discipline. Honorable Justices, before this court can determine if these regulations are valid, it must ensure that every party whose legal rights are affected is present at the table. Honorable Justices, the applicants have approached this court as if traditional healing exists in a vacuum, separate from the communities and the leadership structures that govern them. The respondents submit that the failure to join the Minister of Cooperative Governance and Traditional Affairs does constitute a material non-joinder. The toss for joinder, Honorable Justice, was clearly articulated in the Amalgamated Engineering Union case, where the court held that for a party to be joined in proceedings, they needed to have a direct and a substantial legal interest. Honorable Justices, this is not about who is interested or who wants to be part of the proceedings. This is about whose statutory rights or whose duties will be changed by this court's order. Honorable Justices, the applicants argue that because the Minister of Health is the one that regulated the regulations, so he's the only person who should be in these proceedings. Honorable Justice, that would elevate form over substance. We must look at the substance of this matter. The reality is that traditional health practice is deeply intertwined with the governance of traditional institutions, a sphere that belongs exclusively to the Minister of Cooperative Governance and Traditional Affairs. Honorable Justices, to make it simple for this court, I wish to provide 3 concrete examples of how the Minister of Cooperative Governance legal duties are directly affected. The first one being the oversight of traditional councils. Now, Honorable Justices, Under Section 4, subsection 1I of the Traditional Leadership and Governance Framework Act, it states that traditional councils are legally mandated to promote indigenous knowledge systems. Now, Honorable Justices, traditional councils are governed by the Minister of Cooperative Governance and Traditional Affairs. Traditional healing is at the very heart of those systems. Now, if this court were to strike down these regulations, you would be stripping the Minister of Cooperative Governance and Traditional Affairs Council of the very framework they use to manage their communities. Now, Honorable Justice, as the respondents, we submit that does create a direct and substantial legal interest in this matter. Honorable Justices,
Sorry, before you continue, expand on that point. Expand on the impact of our judgment stripping the minister of his powers.
Honorable Justices, if this court were to decide, were to rule in the absence of the Minister of Cooperative Governance and Traditional Affairs, that judgment, Honorable Justices, would not bind that office. Honorable Justices, as I mentioned, under Section 4, subsection 1 of the Traditional Leadership and Governance Framework Act, it states that the traditional councils are legally mandated to promote indigenous knowledge systems. Now, Honorable Justices, the Minister of Cooperative Governance and Traditional Affairs oversees these traditional councils who are mandated to promote those indigenous knowledge systems. And we submit that at the heart of those knowledge systems, traditional health practices is there. Now, Honorable Justices, as the respondents, we submit that does create a direct and substantial legal interest. Now, if the court were to rule let's say the court rules in favor of the applicants and without the joinder of the Minister of Cooperative Governance and Traditional Affairs, how is then the Minister of Cooperative Governance and Traditional Affairs supposed to regulate under Section 4, subsection 1? That is my submissions to the court.
You say that the judgment would not bind the Minister of Cooperative.
Yes, Honorable Justice.
You say that?
Honorable Justice, I say that because if a party is not joined to the proceedings, the judgment will not bind them.
So all judgments that are made by this court are not binding on the parties that are not before this court.
That's my submission, Honorable Justice. As the court pleases. The second one, Honorable Justice, the second reason we believe that the Minister of Cooperative Governance and Traditional Affairs should be joined in this matter is their statutory role in health. Now, Honorable Justices, Section 20, subsection 1D of the same Act states that to national government, the Act allows national government to give traditional leaders a specific role in health. Now, yes, Honorable Justice.
On the follow-up of the question my brother asked you, your submission is that all judgments of this court are not binding where parties were not joined to those proceedings. So basically, you're saying if you are not party to a judgment of this court, then the judgment doesn't bind you. Is that your submission, counsel?
Or rather put his input in these regulations. So now when the court decides in the absence of that minister, how is then the minister supposed to regulate under Section 4, subsection 1? That's what I meant by the court order will not simply bind them because it will not be inclusive of the Minister of Cooperative Governance and Traditional Affairs.
So not that it won't be legally binding, but that it would not be inclusive.
It would not be inclusive of the Minister of Cooperative Governance and Traditional Affairs, Chief Justice.
I think we want to understand whether or not you understand, I guess, being a president and the force, that this, our judgment is going to come with. We just want to get a clear understanding of your understanding.
Justice. As the court pleases.
Cleared it up.
As the court pleases. Honorable Justices, the third reason we believe that the Minister of Cooperative Governance and Traditional Affairs should be joined in the proceedings is because of the advisory functions on customs. Now, Honorable Justices, if we look at Section 11, subsection 2 of the National House of Traditional Leaders Act, it states that the National House, which is overseen by the Copter Minister, has a statutory right to advise the government on customs. Now, Honorable Justices, the applicants are claiming that these regulations hurt their customs.
Counsel, when these regulations promulgated in terms of the Traditional Health Act,
Can Honorable Justice repeat the question?
the regulations promulgated in terms of the Traditional Health Act,
When
were the regulations not promulgated in terms of the Traditional Health Act?
they were, Honorable Justice,
And which minister is responsible for that act?
the Minister of Health.
So what would how would the Minister of COGTA be materially affected then?
Honorable Justices, the applicants relied,
Dealing with health now.
if we're dealing with health, Honorable Justice, to answer that question, I would like to refer to the case of Amalgamated Engineering Union. Honorable Justice, that case states that for a party to be joined, they need to have a direct and substantial legal interest, and not only on the subject matter, but on their rights need to be adversely affected by the outcome of the court. Now, as the respondents, we are submitting that, yes, Honorable Justice, you can argue that the Minister of Cooperative Governance and Traditional Affairs does not necessarily promulgate the regulations, but the order of the court will affect their rights because they have duties under the Traditional Health Practitioners regulations and the Traditional Leadership and Governance Framework Act, and also the National House of Leaders Act. That is our submissions as the respondents, Honorable Justice. As the court pleases. Yes, Justice.
Because you're submitting that the minister might come and aid the court in terms of the indigenous knowledge presentation. Couldn't they maybe become the amicus instead of the non-joinder?
I would like to disagree with Honorable Justice, simply because as the respondents, we believe that the order of this court will affect the rights of the Minister of Cooperative Governance and Traditional Affairs. So we are submitting that they need the opportunity, they deserve the opportunity to be heard in this matter as a party, because their rights are going to be affected.
In what way are their rights going to be affected?
Honorable Justice, the Minister of Cooperative Governance and Traditional Affairs has rights, or rather they have rights under the Traditional Leadership and Governance Framework Act and also the National House of Leaders Act. Now, yes, the main focus today is the regulations of health. But, Honorable Justice, we can't ignore the fact that whatever decision is taken today, the Minister of Health, because he oversees traditional councils who advise on, who help the Minister of Cooperative Governance and Traditional Affairs advise and promulgate under Section 4, subsection 1 of the Traditional Leadership and Governance Framework Act. That, Honorable Justice, we are submitting that does create a direct and substantial legal interest in the matter. As the court pleases. Honorable Justices, as I mentioned, the absence of the Minister of Cooperative Governance and Traditional Affairs would be a mistake, Honorable Justices, because again, as the respondents, we still submit that the Minister of Cooperative Governance and Traditional Affairs does have a substantial legal interest in this matter. Honorable Justices, the applicants relied on the supplementary heads of arguments. They relied on Section 172, subsection 1, to distance the Minister of Cooperative Governance and Traditional Affairs from this matter. Honorable Justices, Section 172, subsection 1, basically grants this court the authority to invalidate laws that are unconstitutional. And for that to happen, Honorable Justice, the court has to decide a matter on a fair basis. Now, Honorable Justices, we ask a question out of concern. If now this court were to grant that order, how would that be fair if the Minister of Cooperative Governance and Traditional Affairs is not joined and is not allowed to even question these regulations? Hence why we believe that their reliance on Section 172, subsection 1, is weak, Honorable Justice. Honorable Justices, therefore, for the reasons I've provided, we pray that this preliminary objection be upheld. If the court has no further questions for me, I would now like to hand over to my co-counsel.
Just one last question.
Honorable Justice.
On a practical basis, what is the effect of the judgment that, say we are with the applicants? What is the effect of the judgment if we agree with them and uphold their, set aside the promulgation? What is the practical effect? What will happen to the regulations? So we agree with the applicants, we set aside the regulations. What will be the practical implication of the regulations themselves? How does that affect the Minister of COGTA?
Thank you, Honorable Justice. So as we understand as respondents, the practical sense of this, if, for example, the regulations are struck down, Honorable Justice, the Minister of Health would need to redraft or amend those regulations in line with what the applicants have rather wanted, for lack of a better word. Now, Honorable Justices, we submit again under Section 4, Subsection 1 of the Traditional Leadership and Governance Framework Act. The Minister, the traditional councils are legally mandated to promote indigenous knowledge systems. Now, if these regulations are drafted, how, and the Minister of Cooperative Governance is not joined in this matter, how will then the Minister of Cooperative Governance and the respective councils promote the correct way of the indigenous knowledge systems?
I'm asking about the practical effect of if we are with the applicant. If we are with the applicants, we strike down, to use your words, we strike down the regulations, we return them to the minister undergoes the process. Okay. What prejudice will that have if we strike down and we send the regulations back to the minister? What prejudice will that decision have on the Minister of COGTA? Well, I think the Minister of COGTA the decision will have the effect practically, leave the law for now. Practically, it will mean that the regulations go back to the minister redrafts and all of that. So what prejudice will the Minister of COGTA suffer if those regulations go back to the Minister of Health? Is there any prejudice that the Minister of COGTA will suffer?
Honorable Justice, I would like to submit like there is a prejudice, and the reason is because if, as Justice pointed out, if then the minister, for example, were to redraft these regulations, the Minister of Health would then need to, sorry, not the Minister of Health, the Minister of Cooperative Governance and Traditional Affairs would then need to follow those new regulations to.
Remember, if we strike them down, they're going to the minister. So it won't be new regulations that we'll make. So the Minister of COGTA can still participate and do the cultural practices stuff at the drafting of the regulation. So I'm saying, your argument is you are saying misjoinder in this court results in a prejudice to the Minister of COGTA. And I'm saying, do you accept that even if we strike down those regulations, they go back to the minister, there's no prejudice suffered by the COGTA minister?
Does justice mean in
the decision does not have any prejudicial result on the Minister of COGTA?
Does justice mean that, I just want to understand the question, does justice mean that in the meantime, when the regulations are drafted, the Minister of Cooperative Governance will still need to follow the regulations, hence why it would not be prejudicially affected?
So I'm asking you, what is the interest of this court in the minister not being cited? Because the application is brought before this court. It's about the Minister of Health who promulgated these regulations. The applicants are asking this court to strike down the regulations and send them to the Minister of Health. You are saying there's a misjoinder. And as a result of that misjoinder, there will be a prejudice to the Minister of COGTA if we proceed to hear the case of the applicants without the Minister of COGTA. And I'm saying to you, if we agree with the applicants, we strike down the regulations, they go back to the Minister of Health, the Minister of Health redrafts the regulations, procedurally fair, follows all of those things. What prejudice does that decision have on the Minister of COGTA?
Honorable Justice.
Before you proceed, I think because of time, could you please address my colleague's question when you guys come back, when you're rebuttal, because I think that it's a valuable point that was not clearly articulated, and we would like to afford you time to consider his point and his question. Do you understand it, or would you like him to reframe it? But do you understand it?
Honorable Chief Justice and Honorable Justice, I believe I understand the question, but I don't understand it fully.
Okay.
I would like
Think about it practically.
Yes.
And then you will address it when you come back on rebuttal.
So the court is affording us opportunity to rebuttal.
Yes.
The court, please. If I find it.
My name is Roeme Kosana, appearing on behalf of the respondent. I will address issue B, whether the Healers United movement possesses standing to institute legal proceedings in its own name or on behalf of its members. Honorable Justices, before a party may have standing, Section 38 of the Constitution requires that the applicant allege that a right in the Bill of Rights has been infringed or threatened, and they must have sufficient interest in the relief sought. On paragraph 11 of the applicant's submission, the applicants state that they have standing on the basis of procedural failure because of the state's failure to facilitate meaningful public involvement. This, Honorable Justices, is a misleading claim. On paragraph 6 of the facts, the minister published regulations in the Government Gazette for public comment. Not only that, the Department of Health used community radio. The Department of Health used community radio and district offices to publicize roadshows, and this reached out to traditional councils across all 9 provinces. Honorable Justices, the unfortunate part for the applicants is that the record shows that they were also invited to participate in consultation, but they decided to decline the invitation. Furthermore, the applicants also rely, and I quote, on unreasonable intrusion to cultural autonomy. However, it must be emphasized that the rights that cater to cultural autonomy are limited, and the Constitution allows such limitation if it is reasonable and justifiable. Accordingly, the regulations are implemented to balance against the state's constitutional duty under Section 27 to protect health and regulate health care in the public interest. Given that an estimated 80% of the population relies on traditional practitioners for their primary healthcare needs, the minister has a compelling duty to ensure that these services are safe and accountable. The requirements for registration, minimum age, and education are not an attempt to infringe or threaten their constitutional rights, but instead regulation intended to serve and protect the members of the public who use these services. Honorable Justices, the applicants focus mostly on having standing under Section 38D, which is standing under public interest, and 38E, which is standing that record, which is an association acting on behalf of its members. I will address standing in public interest first. The question in limine is not whether the applicants have standing in their own interest or on behalf of their members. The question, my apologies. The question in limine is not whether the applicants have standing in their own. The question in limine is whether the applicants have standing in their own interest or on behalf of their members, not if they have standing in public interest. Therefore, this does not help answer the question before the court. Honorable Justices, I would like to distinguish between an association and a national coalition. According to the Merriam-Webster Dictionary, a national coalition is a temporary strategic alliance formed by multiple political parties to achieve a specific goal, often governing together after an election. On the other hand, an association is a formal, often permanent group of individuals or organizations designed to provide ongoing benefits, networking, or advocacy. In Pryor versus Battle, the court in Pryor versus Battle noted that while constitutional standing is generous.
Just before you proceed, you just gave us a beautiful analogy of the two definitions, and I would assume it's you trying to distinguish why perhaps HUM does not certify to have the standing in this matter. I just want to understand your definition of association. Does the HUM not satisfy that definition that you just gave to us?
The reason that May I proceed?
I was saying, why are you saying that? It's very interesting.
Honorable Justices, it does not have the same, HEM does not have the same, HEM is not recognized as an association, because if that was the case, Honorable Justice, then they would have recognized themselves as an association. So Justice, it's important to note it's important to realize that there is a distinction between the two terms, Justice, and that's why I'm emphasizing on that, so that standing can be given accordingly under Section 38E.
I'm with you there, Council. I'm saying to you, what distinguishes this group, or why are you saying HUM does not satisfy this court to act as an association? I mean, you went on to give us the analog of what an association is, and the other term that I forgot, right? And I'm saying, is HUM not an association? You are saying no. And I'm saying, why are you saying it's not? Can you give us a full brief of why?
HUM acts in the interest of its members. Let's be a definition of association.
This is a good question. The HUM, sorry, Justice, can I please have your question again?
The question is, you went on and you gave us a definition of what an association is. And the other term, national coalition, right? And in your submission, you are saying that the HUM does not satisfy the definition of an association. Am I still what you said, right? And I'm saying, why do you say so? How distinct is this group that you cannot say it is an association? Perhaps it's a national coalition. Yeah.
Okay, thank you, Justice, for your question. So the difference is that HUM would then be, if you look at an association and a national coalition. An association is permanent, and a national coalition is a temporary body. With that being said, Justice, those are the different characteristics between the Healers United movement, an association, and the Healers United movement. And to answer Justice's question, the Healers United movement would not have standing on behalf of its members because, again, I rely on Section 36 of the Constitution, Justice. 36 of the Constitution, Section 30 and 31, which are rights that cater to cultural autonomy, are limited rights, Justice. And limited...
Does HUM not act in the...
Yes, Justice, but
That's right. So it does fall within the definition of association.
Yes. Section 38 requires that a right in the Bill of Rights has to be threatened or infringed. So as the respondent, we're submitting that we acknowledge that that right is protected under Section 38 and that they are a member. However, the rights that the rights that's being that they're relying on, Justice, is a limited right.
Council, Section 1331 separate inquiry. The question here is whether it constitutes an association for purposes of Section 38. If you say it does not, right? But you say that an association has two requirements. But you can just say, if you agree with me, one, it must be permanent, and two, it must act in the interest of its members, right? Is that what you...
An association, may I please...
Please repeat the definition of an association, Council.
An association, according to the Merriam-Webster dictionary, an association is a formal often permanent group of individuals or organization designed to provide ongoing benefit, networking, or advocacy.
with members.
Yes.
In the facts, can you highlight to us from the facts any suggestion that HUM is not permanent? It's a temporary group from the facts. The submission is that it's a national coalition, which means it's temporary, right? So from the facts, where in the facts can you show us that it's a temporary group? In my understanding, I think it was created in 2015, right? It's been like now 10 years now existing.
Justice, thank you, Justice, for your question. Paragraph 2 of the facts, Justice, the Healers United movement recognized themselves as a national coalition, Justice.
I understand that, but I'm asking from the facts, can you show us that this is temporary and the group will dissolve at some point, maybe next year?
Justice, I do not have, the facts do not mention the Healers United movement is a temporary body. However, the reason I was relying on the definition was just to emphasize on that the two terms have a different meaning, and Section 38, the applicants relied on Section 38E, which is associations, Justice. So if the applicants, if the Healers United movement recognized itself as an association, then they would have standing under Section 38E, Justice.
Let's say we agree with you that it is not an association for purposes of 38E. Let's say we agree with you that it is not an association for purposes of 38E, right? Would you not agree with me, and as per your learned colleagues have submitted, that HUM is the voice of many people, and the facts say they act for 8,000 people? Does that not constitute? Is it not sufficient to say that the definition of acting in the public interest for purposes of 38D?
Justices, the question before the court is whether to determine if Healers United movement has standing in its own name and on behalf of their members. So Section 38E is irrelevant.
D.
38
Public interest.
public interest is irrelevant today, Justice.
So you're saying it's irrelevant because they don't rely on it?
It's relevant today because the question before the court is whether they have standing in its own name or on behalf of their members. And the applicants on their submissions focus mostly on public interest and do not address section standing in its own name and on behalf of its members. They mostly focus on those two sections, 38D and E.
Lost counsel, but continue, it's fine.
May I please report? May I please have time to finish my submission? Thank you. Honorable Justices, to summarize our argument as the respondents on standing, the applicants do not have standing to challenge the regulations on the basis of procedural fairness because the minister did comply with procedural fairness. The respondents acknowledge that the rights to cultural autonomy are protected under Section 30 and 31 of the Constitution. However, these rights are not absolute and may be limited under Section 36 of the Constitution. It is submitted that any limitation affected by the impunged regulations is reasonable and justifiable, as the regulations are aimed at protecting public health and safety. Finally, Honorable Justices, the applicants do not have standing in public interest or as an association, as that is not the question before the court. Furthermore, Section 38E of the Constitution confers standing for association, not national coalitions. If the court has no further questions for me, I would like to hand over to.
Just have one last question. So you addressed us on HUM and not the other applicants. Do you accept that they have standing? So your argument is that the first applicant doesn't have standing. That's what you've been addressing us on. So on your argument, do you accept that the second and third applicant have standing?
The reason for that is, again, I rely on Section 31 of the Constitution. I rely on Section 36 of the Constitution, on that those rights are limited rights, Justice. The minister implemented the regulation with the objective to protect public safety, not to infringe the Constitution, the rights of the healers and the association, Justice. An infringement, as the respondent, we submitted, an infringement would be an explicit law that states that the right to cultural autonomy is prohibited. In this case, it's not prohibited, Justice. The objective is to protect public safety. If we say that the rights in the Section 30 and 31 are infringed, then we are saying that we are also infringing on the public's in the public interest, health, and safety.
So, counsel, so the second applicant and the third applicant, then their rights are not affected in any way?
Please, the court.
May it please the court, Chief Justice, Deputy Chief Justice, Justices, my name is Nkosi Mnyamana, counsel for the respondent, and I will be dealing with the third preliminary issue, namely whether this application is barred or alternatively rendered premature by a failure to exhaust internal remedies. The respondents submit that this application is indeed barred by the applicant's failure to exhaust available internal remedies as required by Section 7, subsection 2 of the Promotion of Administrative Justice Act. Justices, the starting point is whether an internal remedy exists within the statutory framework. The applicant's contention that none exist is, with due respect, overstated. In Koyaba versus Minister for Home Affairs, the court does not provide a closed definition of an internal remedy, but it identifies their essential characteristics.
So I think the starting point is for you to make submissions as to whether or not PAJ applies and why.
Whether or not PAJ applies and why. PAJ applies in relation to internal remedies, Justice, in relation to, as per Section 7, subsection 2 of PAJ, which clearly states that a court may not review a decision without following the process of exhausting internal remedies first. So that is where PAJ applies in this situation.
We canvassed this with your learned friends, and they are meant to be getting back to us on rebuttal. I think we had thought that you will deal with that.
Right.
About internal remedies.
Okay.
About what is an administrative action. So you must tell us why you're saying Section 7 of PAJ applies.
Right.
You are saying it applies, and they should have exercised internal remedies. You are saying it applies, but the question is, you must tell us why you're saying it applies.
It applies because, firstly, the minister is a state organ who exercises public power, and the scope of that public power falls within administrative decisions. So that is where PAJA is applicable. If that has satisfied your question, Justice, may I proceed? Thank you very much. In Koyabe versus Minister for Home Affairs, the court does not provide a close definition for internal remedies, but it identifies their essential characteristics. First, they must be provided for by law. Second, they must be available and accessible. And third, they must be capable of effecting redress within the administrative framework. But even if Koyabe did provide for a close definition of internal remedies, for the applicants to contend that neither the Traditional Health Practitioners Act nor the regulations establishes any internal appeal or reconsideration mechanism aims to mislead the court. Section 27 of the Traditional Health Practitioners Act deals precisely with the right to appeal. Section 27, subsection 1, explicitly states that any aggravated party who is aggravated by the registrar's decision may lodge a complaint with the council within 30 days of the date of that decision. Additionally, Section 47 of the Traditional Health Practitioners Act confers onto the minister the power to make regulations. Read together with the Interpretations Act, Section 10, subsection 3, that power includes the power to amend, revoke, and vary regulations. As per Section 7, subsection 2 of PAJA, a court may not review administrative action unless any internal remedy provided for by law has been exhausted. The same principle is reaffirmed in the Tenga Holdings versus Southern Sphere Mining, where this court recognized that a litigant may not circumvent statutory dispute resolution mechanisms by approaching the court directly, where a legislation provides of a capable mechanism that could address the grievances.
Mr. Mnyamana, please, before you proceed,
Yes, Justice.
you cited the act and that there's a section you cited where you say it gives 30 days. That's not in your of arguments. Am I wrong?
No, you're not wrong.
Please state that act again. Internal remedy section.
That is Section 27, subsection 1 of the Traditional Health Practitioners Act, 2007. With your permission, may I proceed, Justice? Thank you. As I was saying, Justices, the same principle is reaffirmed in the Tenga Holdings versus Southern Sphere Mining, where this court recognized that litigants may not circumvent statutory dispute resolution mechanisms, especially where they are available and capable of addressing their grievances. Under the Traditional Health Practitioners Act, a council and register are established to regulate registration, categorization, and compliance of practitioners. The applicant, however, did not engage with the statutory framework at all. They did not apply for registration, they did not appeal any decision, and they did not evoke any administrative mechanism capable of addressing their concern within the statutory framework. And the applicants in their supplementary written submissions are arguing that exceptional circumstances exist, but have failed to demonstrate how they exist. Merely stating that they exist doesn't translate to actual existence. This court held in Koyabe that exemption may only be granted where internal remedies are ineffective, unavailable, and inadequate. No such circumstances arise here. The statutory framework clearly provides a mechanism through which practitioners may engage with the regulatory regime and challenge administrative decisions. The applicants chose simply
indulge us here. What internal remedies are available under the revision of the Traditional Practices Act?
Thank you, Deputy Chief Justice. The respondents are not saying it's a formal internal remedy, but it's a remedy capable of providing effective relief. And Section 27, subsection 1, provides for exactly that. First, it clearly and explicitly states that whoever is aggravated by the decision of the register may appeal that decision with the council. And second, in their submission, they're arguing that only a court can invalidate legislation and subordinate legislation. And the respondents accept that that is true. The jurisdiction of the court is not disputed. What is disputed is that they are trying to bypass the mischief that Section 7, subsection 2 seeks to prevent. They're skipping all the mechanisms that are available within the administrative framework and going directly to court. And as I stated, Deputy Chief Justice, that is the exact mischief that Section 7, subsection 2 seeks to prevent.
Please restate that mischief that you claim they're seeking to circumvent. Please just restate it clearly.
Allowing litigants to bypass statutory mechanisms that are available, all in the name of invalidation or only the Constitutional Court has this jurisdiction. That is not disputed here. What is disputed is the manner in which the applicants chose to deal with this issue, whereas there is a mechanism that could have provided them the exact same relief that they needed. The minister is empowered by Section 47, read together with Section 10, subsection 3 of the Interpretations Act, to revoke these legislations, to amend them, and to... Yes, Justice.
Paragraph 17 of the facts states, on 6 December 2024, APPM addressed a letter to the minister. Isn't that exercising internal remedy?
That's a very good question, Justice. But now, one attempt into isn't necessarily exhaustion, because that is not the only remedy that exists. You need to exhaust all of them. And for them, it's only one attempt. So it is not safe for us to say they've exhausted all remedies that are available. Have they appealed any decision? No. Have they registered under the framework? They haven't. Have they engaged with the minister and said, we'd like you to consider these points and amend these regulations? They haven't done any of that. What they've done is they've addressed a letter to the minister, and unfortunately, they didn't get a response. But also the reality of this is that there are thousands of people. The minister acknowledged receipt of this letter and acknowledged that. Let me just go back to paragraph 17, Justice.
So just to help you, it was a mere acknowledgement. It wasn't a confirmation or denial of anything. I think what I want you to expand upon, and I think your colleague touched on it in the beginning as well, is this concept of constitutional discipline. You are saying that they are essentially embarking in the mischief that is sought to be curbed, which is running straight, to the Constitutional Court and not using what is readily available, from an internal perspective. And then you raise the fact that a letter was submitted, however, they did not do anything further. Are you stating that there were other mechanisms that were available to them? And if they were, how is it that this was not made available to them? I mean, they clearly weren't aware of it. Because, for example, if a letter has been acknowledged, pure acknowledgement of receipt, however, nothing follows to allow, for example, the person who drafted it or sent it over to be able to either challenge, or nothing follows to give them a way of understanding the avenues in which they should then proceed further. Should they be aggrieved by the response itself, or should they be unhappy with a mere acknowledgement? So I would like you to sort of deal with that, as in, you say that there actually were other avenues. They did not follow those avenues. Practically speaking, what were those avenues?
Thank you, Chief Justice. The avenues that were available to them is they could have appealed this decision with the register as established by Section 27, subsection 1 of the Traditional Health Practitioners Act. Their letter.
So before you proceed, is that an internal remedy or it's a statutory process?
It could have provided them the remedy that they seek. It could have provided them effective redress. The letter that they sent to the minister deals with the arbitrary grounds, as they deem, the arbitrary grounds of not being allowed to be part of the council, concerning not meeting the requirements. Now, if they're not satisfied by this specific decision, there's a mechanism that exists within the statutory framework that says, if you're not satisfied by a decision, you can appeal this decision.
Council, the applicants, therefore, they are correct that that is not an internal remedy, however, a statutory process. And if they bypassed it, they are not entirely wrong, because it is not a remedy at the end of the day. Do we agree on that?
The issue here, Deputy Chief Justice, is that they rely heavily on Koyabe, and Koyabe doesn't explicitly label internal remedies to say only this is an internal remedy, but it just provides characteristics of what internal remedies are able to provide. And some of those characteristics include being accessible, available, and being capable of giving appropriate relief. And that is precisely what Section 27 does. It has those characteristics, and it feeds the characteristics of the very same authority that the applicants rely on. May I please just get additional time to wrap up the last bit of my argument, Justices? Thank you, Justices. The authority of Economic Freedom Fighters versus Speaker of National Assembly, which is used by the applicants in their supplementary written submission, is misused in this matter, because that case considers the constitutionalness of Rule 73 of the National Assembly, which provides for a physical removal and subsequent suspension of members who refuse to leave the chambers when ordered to do so. It doesn't deal with internal remedies at all. The application is therefore procedurally barred and alternatively rendered premature because the applicants approached this court without first exhausting internal remedies. Second, they have failed to establish where the exceptional circumstances are. And in light of these submissions, the respondents respectfully praise that this honorable court grants the following relief. First, dismissing the applicants.
Maybe before the relief, could we just, before you deal with the prayers, indulgence from the Chief Justice to give counsel as an opinion on that question I had asked you about the practicalities, and then Mr. Mnyama can come back with the prayers.
Thank you, Justice.
Do you remember the question, or do you want me to repeat it?
Honorable Justice, I do remember the question. However, I would like Honorable Justice to, if there is a way to simplify the question for me, because I'm of the belief that I do understand the question, but my answer that I want to submit is the same that I've submitted. So I do not want to repeat myself.
In the interest of time, I'm going to say that I want you to accept that there is no prejudice that the Minister of Court will suffer if the regulations go back to the Minister of Health. The Minister of Health to do the process through a procedurally fair, etc. manner. You can say you accept that or you don't agree with me when we are done.
With all due respect, Honorable Justice, I don't agree with that.
Thank you.
I have the court, please.
Thank you, Justices. In light of the submissions, the respondents respectfully praise that this honorable court grant the following relief. First, dismissing the applicant's appeal in its entirety with no order as to cause. Second, confirming the validity of the Traditional Health Practitioners Regulations 2024. Third, granting such further and/or alternative relief as this honorable court deems just and equitable. Unless this court has any further questions, those are the submissions of the respondents. And please the court.
All rise.
Before we close, you may be seated. As agreed, the applicants also have an opportunity for a rebuttal, to present their rebuttal.
As it pleases the court, the applicants would love to rebut on what the respondent had said. Firstly, on the first issue of non-joinder, when the speaker came in, the speaker told us that the minister's rights and duties will be affected, and went on and went on. However, the respondent did not tell us which rights and duties would be affected. Secondly, your justices, the respondents misled this court by stating that if you do not join, therefore that decision is not binding to you. Therefore, and he did not even tell us the authority for such an argument case, that direct and substantial interest means that if it is not just of a subject matter, however, if that certain party that has direct and substantial interest is not joined in this matter, it will prejudice them. Your justices, the respondents said themselves that the Minister of Cooperative Governments and Traditional Affairs can act as an advisory. Therefore, by acting as an advisory, as we stated in our heads of argument in terms of on section 172 subsection 1, that the court is the one that declares any legislation or act invalid, not the minister. Therefore, by having the minister there, it doesn't mean that the minister will be the one to make the decision. However, it will be the court that will declare a certain legislation invalid. Therefore, your justices, to conclude, the absence of the minister does not lead to procedural unfairness or does not prejudice the Minister of Cooperative Government and Traditional Affairs. Those were our rebuttals, your justices. I would love to hand over to my learning friend, Henilaga, to rebut on the second issue, your justices.
May it please the court. So I will rebut in the following way, justices, in terms of 8 points. But before that, I want to highlight that what the respondents are submitting to this court in terms of Lucas Dini is actually using what we previously had before the Constitution, of which it is unreasonable. We have the Constitution for a reason, to transform the society and to correct the injustices of the past. First point, the council is saying that we were basing our argument in terms of standing on the procedure. But I had an agreement with the justice to say we are not entirely saying that the procedure itself institute a standing. It was an example. And therefore they are wrong to say that we are saying or we are relying on procedure for standing. Secondly, they are saying the rights of traditional healers in terms of section 30 and 31 are limited. Yes, we do consider that. However, they are missing an important point there. For as much as it can be justifiable and reasonable, section 36 says they can only be limited in terms of law of general application the health is not a law of general application because it only regulates traditional healers. Thirdly, they are saying this.
Sorry. You're saying the Traditional Health Act is not a law of general application.
Thirdly, they are saying the state must protect the public health in terms.
Is incorrect. Here's the law of general application.
You accepted your justice. Apologies. Thirdly, they are saying the state must protect public health in terms of Section 27. Yes, we do agree with that. But now the question is public health limited to hospitals and not traditional healing? Because when you look at the first paragraph of our heads, it says 80% of the population relies on traditional healing. Is that not enough to constitute public health? My fourth point is that, okay, you as the justices addressed this thing in terms of an association and a coalition. I'll just skip it for purposes of time. So they're also saying the second and the third applicant do not have standing. That is wrong, Your Justice, because when you look at Section 38, in paragraph A, it says anyone acting in their own interest. So Section 38 is broad now. So they do have standing in their own interest in terms of subsection A. Okay, for the purposes of time, Your Justices, I will just focus on the last one.
Maybe, sorry, before I'm interested in this, that their argument is that they cannot act in their interests
Yes.
because their rights are not infringed. That is their argument.
Yeah.
You accept that? They're saying that Section 31 and Section 30 and 31 are limited rights, but even if that was not so, cultural rights are not, as I understood the argument. Do you accept that?
Yes, we do accept that they are not absolute justice. But now to address public interest, Your Justices, this is a matter of public interest, right? There is no way we can exclude the interest of the public. There is no way you can exclude that. This is a public interest matter. And therefore, we need to consider standing in terms of public interest as well. Because now, the standing is broad enough to accommodate everyone, not the way it was previously. We have the Constitution for a reason, Your Justice. And as I just said, we are in the era where the Constitution is trying to correct the unfairness and the injustices we had previously. So we cannot interpret this provision or standing in a narrow sense. It must be broad. And those are my rebuttals, Your Justice.
Rebuttal. You premised it as a matter of fact that it's a matter of public interest. Do you have anything to provide the court to substantiate that assertion, particularly in this case?
Yes. Okay, as I previously said, Your Justice, I provided that for as much as we are having the second and the third applicant, they are not the only people who are affected by this thing. My learning friend also mentioned that for you to bring a matter, you must be having what? A threat. The law must be threatening your right. And it is actually what is happening because these regulations are violating the rights of all the traditional healers. There is a threat. I don't know if I have answered your question enough.
So, but this goes back to my earlier question. You accepted that they are saying the rights of applicant 2 and 3. But that's what Section 38 says. Anyone listed has the right to approach alleging that a right in the bill has been infringed. So they are saying there's no rights that have been infringed.
There is a right, Your Justice. And
Okay, that's fine.
And if I can take the court's attention to paragraph 21 of the facts, in terms of the second applicant, paragraph 21, I quote, Gogo Dlamini decided she wanted to begin the formal process of registering with the interim council. After reviewing the requirements, she found the categories rigid and the paperwork prohibitive, feeling the new system disregarded her 5 decades of community recognized practice. So her rights are affected. And also, we can also go to paragraph 12 of the facts. In terms of the third applicant, Gogo Kensani, When you look at paragraph 12, your justices, it says the Minister of Health rejected Kensani Matlangu's regulations. So this is clear enough to show that her right is violated. Okay, thank you, Your Justice. I would like to hand into my co-counsel to rebut on the last issue. Thank you.
Greetings again to your Honourable Justice. Firstly, the heaviness of this robe makes you interpret the color of the desk while you see this desk is brown. Your Honourable Justice, I want to answer your question first before I continue with my answers. You asked what was the action that I was referring to that makes us to consider the perjury. So the applicant submits that the administrative action that was available in this instance, it was provided in section 47 of the Act, which provides that the minister have the power to make the regulation. And in this instance, I've already defined what is an administrative action. So as the applicant, we submit that the administrative action that was done here was the regulation of it was the making of the regulation by the minister, which adversely affected the right, because the regulation was made to give effect to the rights in the Act. So we further submit that the minister, the reason we are saying the minister failed, the minister in this instance is the open state. The section 1 of the Act provides that it is a decision or failure to take a decision. So as the applicant, we are submitting that it was a failure to take a decision in terms of affecting or effecting the right in position. I would like to move to rebutting. Your Justice, the respondent is submitting that there was no internal remedy that existed in law. And they are relying in the case of Kayobe by saying, in Kayobe did not define what a remedy is. But I have a case. In Force versus Minister of Safety and Security, a remedy was defined as a relief granted by a court to vindicate constitutional rights and prevent future violation. And in this instance, the relief that the applicant wants is the regulation to be declared unconstitutional. The respondent submitted that section 27 of the Act, it requires that they must appeal, they must engage, and this appeal is capable of addressing the issue here. We are submitting that the fact that they are saying it is capable of addressing, we're not focusing on the capability. We want a relief to be granted. We want this court to say this regulation is unconstitutional because it violates our applicant's right. We are not measuring in terms of capability. We are not weighing anything. We just want this court to say that this regulation is unconstitutional and it prejudices our applicants. And also, I would also want to answer one of the justice's question about the exception of the by-watch principle. Although I don't have an exact paragraph because of time, I couldn't able to look at the case exactly. But the exception that was provided in the by-watch case, it says that if the private party is unsuccessful, each party should normally bear its own cost to avoid a chilling effect on constitutional litigation. Your Justice, we accept that this is an exception, and the fact that we already paid this court, the respondent must bear the cost. There's no need for us to look at the exception because we want this court to provide us the remedy. If
we are not with you, counsel, and we find in favor of the respondents, should we order costs against you?
No. Thank you for.
That's what BioWatch says. That's what the principle you just said.
Can you repeat that, Your Justice?
BioWatch. It follows from my brother's question that you are saying from that what you've just said, then we should order, if we're not with you, then we should order costs against against you because you are wanting a remedy, and that remedy must follow the whatever decision we take. The costs should follow the suit, and you seem to be disagreeing with BioWatch that each party must pay its costs.
Your Honor of Justice, I'm not disagreeing with what BioWatch principle, but I'm saying this court cannot grant us the cost because, as you just said, we want the respondent to bear the cost because they're the one who are violating our rights.
If we are not with you, what should happen to costs? If we are not with you and we are with respondents, that's what my brother is asking.
Then the exception will have to apply. I agree with the justice. Thank you for the question. If the justice of this may I please continue.
Chief Justice, Justices, the respondent just wanted to find out if we'll still be afforded the chance to say rebut because earlier the court had said that we will.
I was responding to your colleague. Yeah,
Specifically.
that was the question that I had asked.
Thank you, Justice.
We are conscious of time, so we'd like to break and judgment is reserved.
All rise.
This team.
Stand here now, Messi. Here. Beautiful.
Nice. This
Take more. Happy that we done.
Yeah. But now I'm happy
We
that
were very nervous in the start, but now that we're done, we're like,
It was really too much. Yeah, just I mean, no, it was relative. Yeah. His way, which is what we like.
Can we take a picture together? Yeah.
We need
Yeah.
let's take a picture with the applicants.
We could have settled this out of court.
I think it's
Oh, you guys, you look so good.
Thank you.
Beautiful.
Thank you.
Want to do an athlete? Yeah, of course. Looking after the judges? I'm so Please.
take this one.
Open, yes.
The Constitutional Court is now in session, calling case number CCPIL 6 of 2026 in the matter between Healers United Movement and others versus Minister of Health and others. Presiding officers are Chief Justice Khababete, Deputy Chief Justice Matlala, Justice Poshori, as well as Justice Dumani. Court is now in session.
Greetings, my honorable justices, and may it please the court. Standing before you is Leta Mobi. Alongside with me are my co-counsels by the name of Fiso Mashala and Silo Mhlele, and we are appearing on behalf of the applicant. If it pleases the court, my honorable justices, within the 30 minutes of this court's time given to us, I would like to take the first 9 minutes of this court's time to discuss the first issue of a non-joinder. My co-counsels will each take 8 minutes of this court's time to discuss the second issue of requisite standing and the last issue of exhausting internal remedies, and to conclude with the third. And with the permission of this court, we would like to reserve 5 minutes for rebuttals. If it pleases the court, my honorable justices, before I proceed with my submissions, I would like to address the issue of jurisdiction. My honorable justices, in terms of section 167, subsection 3 of the Constitution of the Republic of South Africa, the Constitutional Court is the highest court in the land and may decide on all constitutional matters and any other matter that the Constitutional Court grants a relief on the appeal on the grounds that it raises an arguable point of law of general public importance that ought to be considered by that court. If it pleases the court, my honorable justices, I would like to proceed to my submission. My justices, as the counsel for the applicant, we respectfully submit before this honorable court that failure to join the Minister of Cooperative Governance and Traditional Affairs does not constitute a material non-joinder. In this matter, my honorable justices, as seen in paragraph 23 of the set of facts, the Healers United Movement launched an application to the High Court challenging the validity of Section 47 of the Traditional Health Practitioners Act. Their relief sought, my honorable justices, was directed at the Minister of Health and the Interim Council, who exercised their regulatory power under Section 47 of the Traditional Health Practitioners Regulations, and not the Minister of Cooperative Governance and Traditional Affairs, as he played no role in promulgating and enforcing those traditional health regulations of 2024. My honorable justices, the test for a non-joinder is well established in the case of Amalgamated Engineering Union versus the Minister of Labor, where the Supreme Court of Appeal held that a non-joinder arises where a party with a direct and substantial interest in the relief sought is absent from the proceedings, and when no such interest exists, there is no material non-joinder. It further held, my honorable justices, that the inquiry is whether a party has a legal interest in the subject matter that may be prejudiced by the court's order. My justices, this was further emphasized in the case of the Organization Undoing Tax Abuse, NPC, where the applicant sought to have Duduzile Mieni to be declared as an unfit director in terms of Section 192 of the Companies Act, based on her conduct and in the company of the South African Airways. And during the proceedings, my honorable justices, she raised a defense of a non-joinder, stating that their failure to include the Minister of Finance constituted a non-joinder. She relied on the fact that the Minister of Finance had a statutory oversight on the state-owned enterprises. She argued, my honorable justices, that because the company of the South African Airways, when they had made transactions, my honorable justices, the Minister of Finance had to make consent. But in this matter, my honorable justices, the court dismissed her application, stating that the relief sought was directed at her and not the Minister of Cooperative Governance and Traditional Affairs. And it further stated that the administrative involvement and indirect oversight does not suffice to meet a test of non-joinder as per the case of Amalgamated Engineering Union. This is the Minister of Labour. My justices, these provisions emphasize that for a party to be joined, they must have a direct and substantial interest in the relief sought. And in this matter, the respondents themselves fail to demonstrate prejudice to the Minister of Cooperative Governance and Traditional Affairs. And their omission, my Honorable Justice, underscores that they themselves did not regard the Minister of Cooperative Governance and Traditional Affairs as indispensable from the beginning. In paragraph 12 and paragraph 13 of the argument of the respondent, they argued that the High Court's silence on the objection of a non-joinder was regarded. The absence of an objection on a non-joinder was regarded as ignorance, but we as the counsel for the applicant respectfully submit before this honorable court that the silence of the High Court was not a matter of ignorance, but it is a judicial recognition that it had before it the correct respondents, which were the Healers United Movement and the Interim Council. My justices, thank you, Justice.
Just out of interest, we find ourselves at a constitutional court, a final judgment. Won't you agree with me? Perhaps the omission of the court in this matter, even though they might not have a direct prejudice. But remember, this matter is a matter of public interest. And when a court of this stance has to make a final judgment, there are certain elements that we need on the requirement. And since this matter is of public interest, don't you think that joining the minister aid the court a fair judgment, even though they might not be directly prejudiced, having them coming as non-joinder, they can come in and help us in terms of giving us insights about the business and also seeing that they oversee as the traditional council in terms of the practices of traditional practice.
Thank you so much for your question, my Honorable Justice. In response to that, I would like to respectfully refer this court's attention to Rule 10, Sub-Rule 3 of the Uniform Rules of the Court, which stated that a party may only be, a non-joinder arises where a party with a direct and substantial interest in the relief sought is absent from the proceedings. It is also seen, my Honorable...
By the Uniform Rules of Court, Constitutional Court.
No, my Honorable Justice. To proceed with my submission, my answer to you, my Honorable Justice, in the case of an independent electoral commission versus the London municipality, this honorable court stated that a party may only be joined in the proceedings only if they have a direct and substantial interest in the relief sought.
Just before you proceed, I'd like to in the case. Could you just give us a brief understanding of what was happening in the case before they came to the decision, and how is it binding to today's
Thank you so much for your question, my Honorable Justices. The case of Independent Electoral Commission versus London Municipality was heard by this Constitutional Court in 2010, where the still by municipality obtained a relief in High Court to compel the Independent Electoral Commission to create another voting station, but the IEC, which is the Independent Electoral Commission, went to court and stated that when they obtained the relief sought, they were not included in the proceedings. And that is when the court established the principle that only a party that has a direct and substantial interest in the relief sought should be included in the proceedings. And because the relief sought will directly affect the powers of the Independent Electoral Commission, they had the necessary direct and substantial interest in the relief sought.
That follow up to my sister's question. That precedent read with the earlier case that you cited of you said Miene excluded administrative involvement? Like, are you saying the minister by his administrative role does not have any substantial interest in the matter?
My Honorable Justices, if it pleases the court, I respectfully beg for a simpler context of your question.
So you're saying the Minister of Copter has administrative oversight and administrative role that he paid.
Yes, my Honor.
So are you saying that is not a substantial interest in the matter?
Yes, my Honorable Justice.
So merely administrative interest is not substantial interest in the matter. Is that what?
Yes, my Honorable.
Just to follow up, I agree that there's a constitutional duty to support traditional healers, and ministers' presentations or submissions in relation to the regulations would be beneficial. It would be beneficial for us to hear from the minister what they would have to say regarding,
Thank you so much for your question, my Honorable Justices. Even though the Minister of Cooperative Development and Traditional Affairs has the regulations by the Constitution that governs him to have an interest in this matter, I would like to refer this court's attention to Rule 10 Sub-Rule 4 of the Uniform Rules of the Court, where it was stated that a non-joinder arises where the questions of law are substantially the same. The question of law in this matter is the validity of Section 47 of the Traditional Health Practitioners Regulation, and not the cultural the statutory oversight, or rather the culture of the traditional leadership, and the questions of law are not the same. So even if he has a direct and substantial interest, he still doesn't even if he has a statutory oversight, he doesn't have a direct and substantial interest, because the questions of law are not the same.
Counsel, you were asked earlier if this court is bound by the rules that you refer the court to and considered.
My Honorable Justices, I respectfully beg for simpler context.
Considered, you agreed. You said the court is not bound.
Yes, my Honorable Justices, because there's some of other rules that apply only in the High Court. But there's some of the exceptional rules, for example, Rule 8 or the Rule 12 Sub-Rule 1 of the Uniform Rules applies in the Constitutional Court. So
Does that include the rule that you just relied on? Right? What is your basis for relying on that specific rule?
it is persuasive, my Honorable Justices, in order to bring the necessary parties before the
is there not a rule in the rules of the Constitutional Court? It's the same thing.
My Honorable Justices, before answering your question, I've realized I'm running out of time and I would like at least 30 seconds of it. Can you please, I respectfully ask for a simpler context of your question?
The question is, Rule 10 deals with, Rule 3 deals with the issue of joinder, right? That you make submissions on. Asking, since we're not bound by that rule, don't you want to cite a rule in the rules of the Constitutional Court that deals with the same issue? A rule that you know of the Constitutional Court that deals with the same issue.
Thank you, my Honorable Justices. If it pleases the court, my Honorable Justices, I would like to refer this court's attention, even though it is not originally included in our written submissions. But in light of Rule 6 and Rule 5G of the Uniform Rule of the Court, I respectfully seek a leave to bring up the case of Kaunda versus the President of the Republic of South Africa. My Honorable Justices, this case was held in the Constitutional Court, and the matters of this case are that Mr. Kaunda and other citizens of South Africa were convicted in Zimbabwe after an alleged involvement in coup attempt. And they sought a relief directly to the President of the Republic of South Africa, asking him to provide a diplomatic protection. And the Zimbabwean government was not involved in the proceedings, and they argued whether the exclusion amounted to material non-joinder. But this honorable court held that there is no material non-joinder, firstly because the relief sought was not directed to them, and the substantial outcome or the ruling of the case would not prejudice their rights. If there are no further questions, my honorable justices, and if it pleases the court, I would like to allow my co-counsel to proceed with the second submission.
Just one counsel. The applicant perhaps the prerogative of the minister who is not joined to these proceedings functions. This is broadly speaking. The applicants have an understanding of the function of the minister
Yes, my honorable justice.
prescribed to him by the constitution.
Yes, my honorable justices. Honorable justices, I would like to hand over to my co-counsel to proceed with the second submission. So please the court.
Greetings, my honorable justices. My name is Muthala Sello. As my co-counsellors already introduced me.
Please speak up.
Greetings, my honorable justices. My name is Muthala Sello. As my co-counsellors already introduced me, and I'll be dealing with the second issue, which is whether the Healers United Movement have the prerequisite locus standing to institute this matter before this honorable court. If it pleases the court, I'll now like to begin with my submission. Locus standing, my honorable justices, is defined as the ability or a right of a party to bring a matter before a court. It is also a substantial requirement that determines whether a litigant's interest is sufficient enough to justify judicial intervention. In our law, in South Africa, Section 38 of our Constitution provides for a codified approach in which a litigant may approach a court to seek relief. Under Section 38 of our Constitution. In this matter before this honorable court, my justices, the applicants rely primarily on Section 38, subsection E of the Constitution, as an organization that brings this matter before this honorable court as an organization that represents the interest of its members. Further, my honorable justices, this locus standing was also discussed in the case of South African Riding for the Disability Association versus the Regional Land Claims Commission. In this case, my honorable justices, the issue before the court was whether South African Riding, as a non-profit organization, had the requisite locus standing to object to the land claims rights that were already given to another participant. In this case, my honorable justices, the court declared that for locus standing to be established, the litigant must have a direct and substantial interest in the relief sought. In the present matter before this honorable court, the Healers United Movement is an organization that represents 8,000 of its members. The 2024 regulations promulgated by the Minister and the Department of Health directly affect its members, their ability to practice their well-being, and the overall traditional profession. Further, my justices, the regulations were promulgated without following directly fair procedures, which then violated Section 33 of the Constitution. This violation, my honorable justices, has therefore created a locus standing for Healers United Movement as an organization that seeks to represent its members to bring this case before this honorable court.
So, what are the provisions of Rule 33? Section 33 Constitution, which you say contains a right which was violated by the promulgation of
the question, my honorable justice. My justice, Section 33 of the Constitution protects the rights of the administrative rights of citizens. Section 33, subsection 1 provides that the administrator must provide for a firm, reasonable, and procedurally fair administrative process. To give effect to Section 33, it was also promulgated, the promotion of administrative justice action promotion of Administrative Justice Act was also promulgated to give effect to Section 33 of the Constitution, my Honorable Justice.
Can I just follow up on that? I'm looking at your heads, paragraph 22 of your heads. It seems to me that you are suggesting that section 38, paragraph 22 of you say, modifies and expands the principle of standing. It seems to me that that is a suggestion that that is not where the authority of standing is sourced. It seems to me that you're saying that some section 38 is some secondary source of law as far as standing is concerned. I don't know if you hear what I'm saying. Hear what I'm saying?
Thank you, my Honorable Justices. It is not a primary, it is not a secondary source, because the Constitution, as provided under Section 2, it is the supreme law of the land and is the primary source of law in South Africa. If it pleases the court, I would now like to continue with my submissions. In this matter, before this Honorable Court, my Justices, the Healers United Movement primarily rely on Section 38, subsection E. And it also established standing under the case of South African Writing for the Disability Association. Furthermore, Honorable Justices, disputes regarding representativity raised on the record cannot defeat Healers United Movement standing. HUM, as provided by the first paragraph of the set of HUM, as provided by the first and second paragraph of the set of facts, is a coalition, is a national coalition that represents the interest of traditional healers. It exists in all 9 provinces of South Africa. And as provided by the second paragraph of set of facts, it aims to represent the interest of traditional healers, its members, and also the broader general public who rely on traditional medicine for their primary health care. This, therefore, my Honorable Justices, states that Healers United Movement does suffer privileges from the 2024 regulations promulgated by the Minister itself as an organization. Its members are affected, and the promulgation also further affect the broader general public who rely on Healers United Movement services. We, therefore, my Honorable Justices, as the counsel for the applicant, submit before this Honorable Court that the Healers United Movement does have the prerequisite locus standing to institute this matter before this Honorable Court under Section 38, subsection E of the Constitution. It was further stated, my Honorable Justices, in the case of South African Navy versus the Tibila Institute of Education and Training, where in this case, in this matter, my Honorable Justices, the Tibila Institute instituted a matter before this Honorable Court under Section 9 of the Constitution. Under Section 9 of the Constitution, the rights which were being violated were the right to equality under Section 9. And the court stated that the court recognized individual organizations' ability to represent the interest of the public.
Also, mention of the interest of the public, but your submissions, and you can maybe bring clarity on that area. Submissions are that the HUM, relying on Section 38E, which basically provides that an organization can have standing when it's acting in the interest of its members. So now are you then saying the interest of the members of the organization equate to the interest of the public or public interest? Which is which?
Healers United Movement primarily rely on Section 38, subsection E, as an organization that represents the interest of its members. As provided by the set of facts, my Honorable Justices, as provided by the first paragraph of the set of facts, my Honorable Justices, 80% of the Black South Africans primarily rely on traditional healers for their primary health care. This, therefore, my honorable justices, we can conclude that any act that affects the Healers United movement, its members, also affects the broader general public, and it gives the Healers United movement further secondary and local standing to institute matters on behalf of the public.
Thank you, Councillor. And what criteria should the court apply? Because now, as I understand your submissions, your initial standing is found under section 38. The secondary will be it's acting in it. What's the criteria that the court should use to establish that your organization or the HUM can act on behalf of the interest of the public?
Thank you for the question, my honorable justice. My honorable justices, through the enactment of the legislation, through the enactment of the National Health Act and the Mental Health Care Act, states that the legislature intends to make Section 27, which provides for the access to healthcare and access to healthcare to be a priority within the country. My honorable justices, the Healers United movement, as traditional, its members as traditional healers, they also counter or support, provide 80% of the general public with primary health care.
In the interest of time, I will simplify. What is public interest? That's the question ultimately.
Thank you for the question, my honorable justice. Public interest will be a matter that is instituted before the court that affects the broader general public.
The court required to have regard to the number of people affected by regulations, for instance.
If it pleases the court, my honorable justices, I'd like to for an extension of 1 minute to.
Please proceed, Mr. Mkhize.
My honorable justices, that it does not, because Section 38 of the Constitution that provides that any organization can institute a matter before a court. It does not specify that the organization has to have a specific number. However, my honorable justices, we cannot ignore the fact that 80% of the Black population of South Africa relies on primary health care from traditional medicine. Also, further, my honorable justices, we cannot ignore the history of South Africa and the apartheid government through the enactment of the Black Administration Act and the Bantustans Act. Although my honorable justices, these acts are no longer effective, however, their legacies can still be seen within the communities of South Africa. These acts, when they were still in power, they aimed to remove the access of healthcare from majority of South Africans, and they diminished their act and the National Mental Health Care Act. And further, the drafting of the NI bill. It then shows that the legislature intends to make or provide for access to healthcare. However, these access to healthcare are not provided equally across all parts of South Africa, which is why in paragraph number 1 of the set of facts, 80% of the Black South Africans of South Africa still rely on the primary healthcare of traditional healers instead of the mainstream medication provided by the government.
Thank you, Councillor. Thank you.
Thank you, my honorable justice. In conclusion, we, as the counsel for the applicant, therefore submit before this honorable court that the Healers United movement have the prerequisite local standing to institute this matter before this honorable court, and its disputes regarding its representativity cannot defeat its standing. If it pleases the court, my honorable justice, I would like to confer to my third counsel who will be dealing with the third issue.
Greetings, my honorable justices. My name is Fiso Mashala, as my co-counsel has already introduced me. And I also extend my greetings to everyone who's inside this honorable court. I'll be addressing the last issue of whether this matter is premature before this honorable court by not exhausting internal remedies in terms of section 7, subsection 2 of PAJA. My honorable justices, as the counsel for the applicant, we submit that this matter is not premature and is properly before this honorable court. We take into consideration, my honorable justices, that section 7, subsection 2A states that no court or tribunal should review an administrative action unless internal remedies have been exhausted, provided in any other law. My honorable justices, there is a general, yes, my honorable justice.
Get to section 7 of PAJA.
Yes, my honorable justice.
Justice Court, PAJA. The Justice Court PAJA applies.
Thank you, my honorable justices. Before I can go straight to the Promotion of Administrative Justice Act, I need to start with section 33 of the Constitution. Section 33, subsection 1 states that it guarantees everyone the right to have an administrative action that is lawful, reasonable, and procedurally fair. And that section calls for the legislature to implement a legislature that gives effect to that section. That's where PAJA comes in, because it provides steps that administrators should follow when they do administrative action or when they take decisions that affect the people at large.
Take administrative decisions.
Oh, thank you for that, my honorable justices. The Promotion of Administrative Justice Act, it gives effect to section 33 of the Constitution. You can go, in terms of section 3, also in terms of section 4. Section 3 says that when the administrative action affects any person. Section 4 states that when administrative action affects the public at large. That's where there are steps that the administrator must follow in order to make sure that administrative action is fair and procedurally, is lawful and procedurally fair.
What constitutes an administrative action in terms of public and facts? How can you apply the facts to show that the decision constitutes an administrative action?
Thank you for that question, honorable justices. Section 1 of PAJA defines an administrative action as a decision or failure to take a decision by an organ of state, a natural person, or a juristic person when performing public function or exercising public power. In this matter, my honorable justices, the Minister of Health has promulgated a 2024 regulation in terms of section 47 of the Traditional Health Practitioners Act. He is acting with accordance to an empowering legislation. That's where comes in the PAJA, and to ensure that people have administrative action that is lawful, reasonable, and procedurally fair. Thank you, my honorable justices. I'd like to continue with my submissions. In the case of Koyabe versus Minister of Home Affairs, this is one of the cases that addressed the issue of exhausting internal remedies in this constitutional court. In this constitutional court, my honorable justices stated that an aggrieved party must take reasonable steps to exhaust internal remedies where available. It further stated that the requirement of exhausting internal remedies must not be imposed rigidly. Shall it be used to frustrate the efforts of the aggrieved party to obtain remedies or to avoid judicial review? As the counsel for the applicant, we submit that non-internal mechanism existed of granting the relief sought. My honorable justices. The challenge in this matter, the applicants are challenging the constitutional validity of a regulation promulgated in terms of section 47 of the Constitution. I would like to bring this example to this court, if this court allows me. My honorable justices, the interpretation of section 7, subsection 2A, it states that an internal remedies must be exhausted that are within any other law. For an example, an Immigration Act 13 of 2002, which was dealt of in the case of Koyabe versus Minister of Home Affairs. It provides internal remedy provisions that allows aggrieved parties to challenge administrative actions within the statute itself. The Traditional Health Practitioners Act, my honorable justices, did not give any chance for the aggrieved party to do that. My honorable justices, we therefore submit that no internal appeal, no complaint, no administrative reconsideration processes empowers any official within the Department of Health or the interim council to set aside, suspend, or invalidate those regulations.
It's just a question, especially internal remedies. Would you not say that the participation in terms of the draft publication, stakeholder consultation was a mechanism, or rather a process, that we can say it amounts to internal remedies available to the applicants?
Also, as you answer that question, your learned friends are also raising that issue, that they are saying the process itself is the internal remedy. As you answer the question of my sister, please consider that as well and address us on that.
Thank you, my honorable justices. My honorable justices, I would not consider the notice that was taken or the procedure itself, because itself did not follow the procedural fairness, because it excluded meaningful participation that was required in this matter. Hence, the applicants have written in terms of paragraph 17 and paragraph 18, it stated that the applicant has furnished the Minister of Health with a formal letter containing grievances that affected them. The minister failed to furnish the applicants with a reason to that. That shows that even the process itself was flawed. It did not allow public participation, and they can never consider it as an internal remedy that the applicants can exhaust.
So you say it was flawed. Do you accept that it exists? There's a difference. You accept that you say it was flawed.
Yes, my honorable justice.
You accept that it exists, because your suggestion is that it was not there for you to exercise. So do you accept, is your submission that it exists, but it is a flawed process?
No,
You say it does not exist at all, so there was no way of having going through it.
Thank you for the question, my honorable justices. Also taking account of the time, I would like to address or answer your question. According to my argument, my honorable justices, we submit that no internal remedies existed. The respondent, they fail.
So you're saying the consultation process is not an internal remedy?
Yes, my honorable justices. They failed to include or to consult those who are adversely affected by the decision. And they also do not want to take accountability of their actions, that this indeed violated the rights of the applicants.
Council, while on that, I would like us to go back to what constitutes an administrative action, right? Because the definition in itself, it's not saying it's a decision. They are also saying it's a failure of a decision.
Yes, ma'am.
And in this regard, we need to acknowledge that the consultation process, it could amount to actually an internal remedy. I'm going back to the question from the Chief Justice, which he asked to say, do you accept that there was, but it was flawed? That's what we wanted to hear from you. But if you're saying it was not, then what do you say about the consultation process that was there? Either it was a failure, but there was an action that was taken, and that is the consultation process. Even though it failed, can you just acknowledge that there was the internal remedy, or that consultation process does not, in fact, amount to internal remedy?
Thank you for the questions, my honorable justices, and your elaboration. As the counsel for the applicant, we submit that consultations, my honorable justices, was never an internal remedy. It is not a remedy, but a public participation that people can also get into when it comes to an administrative action. Looking into it, into time, my honorable justices, I would like to beg this court's time 30 seconds so that I can wrap up my argument.
Please proceed.
Thank you, my Honorable Justice. We therefore, as the counsel for the applicant, as this matter implicates constitutional rights that are contained within the Constitution as a supreme law of the country, this matter insisting the applicants to exhaust non-existing internal remedies would result as an irreparable prejudice to their rights. We therefore submit to this matter that this matter is not premature and is properly before this honorable court, and the applicants are entitled to be here in terms of Section 7, subsection 2C of PAJ, and the matter should be adjudicated on its merits. My Honorable Justices, should I conclude with the prayers, or my prayers are considered?
Please conclude with the prayers, but I just want Rebuttal, please, I have a question about, I know you didn't deal with this, it's not for this point, it's about standing. You didn't deal with this, Mr. Moshele, this is Mr. Moshele, that where you speak about Section 33 and heads of argument, you speak about how the violation of rights in itself establishes standing. So please maybe deal with whether you still persist with that argument. I'm worried if you're saying the violation creates standing, you're saying standing would have not been created if there was no violation. So you can say you no longer persist that argument in the heads of argument, or you can elaborate on what you meant in as far as that is concerned. I don't know if there's questions, but yeah, you may proceed with the prayers.
Thank you, my Honorable Justice. As the counsel for the applicant, we pray that this honorable court declare that failure to join the Minister of Corporate Governance and Traditional Affairs does not constitute a material non-joinder, as the minister did not have any substantial, direct and substantial interest in the matter. We therefore pray that the HUM has a requisite standing to bring this matter before this honorable court as contemplated in Section 38 of the Constitution. We therefore pray that this matter is not premature and properly before this honorable court, as there were no existing internal remedies that the applicants could exhaust in this matter, any or other alternative reliefs that the courts may grant in this matter. Thank you, my Honorable Justice.
What about the issue of costs?
Thank you, my Honorable Justices. We also pray that the respondent bear the cost of this application in terms of the bypass principle, that the matter is of constitutional matter and should be adjudicated in this matter, and they should take accountability on that.
In terms of which principle?
The by-watch principle.
You're saying what is that principle? Sorry, Justin. That principle. You're saying they should bear costs.
Yes.
Of that principle. What is that principle?
Please consult me.
You may.
Thank you, my Honorable Justices. The by-watch principle, my Honorable Justices, it states that the respondent should pay the cost where this matter is at their fault.
Find in favor of the respondents, what should happen as to costs?
My Honorable Justices, that would be the issue of the court to decide which party gets the.
Inclined to hear what you have to say. Convince us.
Thank you, my Honorable Justices. In this matter, my Honorable Justices, it is more, for my opinion, it is more likely for the applicants to be given this, as much as allowing administrators and allowing people to take advantage of vulnerable people would dim the purpose of social justice that is given to everyone.
Mr. Mashala, you've made your case.
Thank you.
As far as why the applicant will succeed. You're asking about costs. I think my brother is asking, what should we then do with costs in the event with the respondent? You've given us BioWatch and you're saying BioWatch must apply for the things you've stated.
Thank you, my Honorable Justice.
What must happen then in the event with the respondent?
Thank you, my Honorable Justices. in the response, in an event whereby the respondent, the court favor of the respondent, then as the applicant, we may but the cost is for the compensation of this matter. Thank you.
Personally,
Court is back in session hearing case number CC-PIL 6 of 2026.
May it please the court. Chief Justice, prior to making my submissions, would it be okay for me to approach the bench? We have a file of sources tabulated just so it's easier to follow during our submissions. Thank you, Justice. Chief Justice, Justices of the Court, good afternoon, actually. My name is Sandisewe Zwane, and I appear as counsel for the respondent, the Minister of Health. Alongside me, I have my co-counsel, Mr. Anele Desi. For my submissions today, then, I will address the court for 15 minutes. Comparatively, my co-counsel will address the court for 10. The court has directed the parties to address 3 preliminary issues. The first is whether the failure to join the Minister of Cooperative Governments and Traditional Affairs, Kiranat Kogda, constitutes a material non-joinder. The second is whether HUM has requisite standing to institute proceedings in this honorable court. The third, then, is whether the application is barred by a failure to exhaust internal remedies. The respondent's answers are clear. The first is that the applicant did not join the Minister of Kogda, and that omission is material. The second, then, is on standing. The respondent is of the view that the applicants have standing or have requisite standing to institute proceedings in this honorable court. And the third, then, is that the application is premature because internal remedies were neither exhausted nor excused. I will address the court on the second and third issue. This is requisite standing to institute proceedings and the exhaustion of internal remedies. With respect, then, to requisite standing to institute proceedings in this honorable court, the respondent accepts that the Healers United movement has requisite standing to institute proceedings with respect to Section 38E of the Constitution. You can view our submissions then in our supplementary heads on paragraph 17 to 22. Moreover, the respondent, Justice, then, submit that this is a non-contentious issue. The courts issued directives, and in paragraph 3, the position of the respondent then is the fact that HUM has requisite standing in and of themselves. But secondly, then, Justice, I just wanted to note with respect to the applicant's case. The first is, one, we don't contend standing, we accept that they have standing in the first place. But secondly, the cases that they cite, despite not being paragraphed, is the fact that the case that they cite towards the end of their submission, this is the South African Navy v. Tabila Institute of Leadership, does not deal with standing, but rather the requirements for recruitments, for age requirements for recruitments of the Defence Force Justice.
If the respondent does not contend or have an issue with standing, isn't that the end of the metaphor with regards to that issue? I mean, you might make submissions that they cited the wrong case or that case is not relevant. But if you don't have an issue or contend standing, then can we not move to another issue that...
Well, yes, Justice, I am going to move on now into the exhaustion of internal remedies. With respect to that, it's a note that the respondents wanted the court to be aware of in and of itself.
Counsel, before you move, I just wanted to understand, I mean, standing is standing. But, you said you agree with that they have standing in terms of section 38 1D.
Section 38E of the Constitution, yes. Moving on then, Justices, to my submission on the exhaustion of internal remedies. Justices, if I may direct you to section 7.2 of the Procedural Administration's Justice Act. Section 7.2 broadly describes that if an applicant has internal remedies available and fails to pursue them, the court cannot hear the matter. The application is premature and must be dismissed. This is further confirmed in paragraph 37 of the case in Ndenge. The statutory purpose of section 7.2 reflects a deliberate constitutional choice that disputes must be addressed within the administrative system before courts are called upon to intervene. With respect then to an internal remedy which was available to the applicants, the respondent submits the following in that regard. There was an explicit remedy that existed in which the applicants did not exhaust. Section 6.1e of the THPA, if the justices can please be directed to there, states that the council may consider any matter affecting the registration of traditional health practitioners and make representations or take other action in connection therewith. How does then the respondent interpret then this particular provision within the THPA? In interpretation then, your justices, the counsel for the respondents invoke the interpretation principle outlined in Ndumeni, particularly within paragraphs 17 to 20 of this case. In Ndumeni, they highlighted that the interpretation principle is now a unitary process or unitary inquiry. This is to say then, how we particularly look at provisions within legislation or words within legislation is based, one, on context, secondly then language use, and the third, the purpose of the act in which the provision exists in and of itself. With respect then to section 6.1e, the first then with respect to context. Particularly the context in which section 6.1e states is under the functions 1 of the interim council, but secondly then, it speaks on any matter affecting the registration of traditional health practitioners.
Before you proceed, I would like you to take us on to the understanding of the determination of what an internal remedy is. Insofar as you went and invoked section 6.1 of the THP, right? And in my understanding, I want to understand, why do you say there is it serves or it can amount to be an internal remedy that was supposed to have been exhausted by practical?
Well, Justice, with respect to the respondent's understanding then of what an internal remedy, if I am to understand you correctly with respect to the question, an internal remedy is a remedy or action available for the applicants to take which is able to contend or address the issues in that application in and of themselves. So with respect to section 6.1e, we are of the understanding that the council is able to attend to the grievances made by the applicants within their submissions within that regulatory scheme under section 6.1e and address that matter thereforth. But
to give examples on that, what are the examples that you'd say they were exhausted? You are giving a provision here,
Yes, Justice.
It regulates whatever the internal remedy is. And I'm saying within that regulation, because a provision is just a provision sitting there. Let's take it to practical now. What can you say, what can you point out to say this is what was supposed to have been used in terms of this provision? This provision gave us an effect to use this certain element, as a remedy.
Well, Justice, with respect to that, section 6.1e, as it broadly states, deals with the matters of the registration of the traditional health practitioners. The regulations broadly then regulate that in and of themselves. This directly then shows the applicants that in any instance that there's grievances, a body exists within the Department of Health, this is to say the interim council, to deal with that matter. In this instance, then it would be any grievances that they have brought forward in their application in and of themselves. So on a practical level, it outlines the fact that any matter that has to be due with registration or of traditional health practitioners is one that the council is competent to deal with in any way, and as such forms a remedy for the applicants. Yes, Justice.
Before you move on, Council, still on that, what do you understand the case of the applicants before this court? Maybe perhaps, the relief sought by the applicants in this court.
Well, Justice, on the case or on the application's heads, paragraph crucial 30 to 33 is where they make the case for internal remedies within their heads of arguments. From what I understand the case to be, the contention exists on two to threefold from the applicants. The first contention is the registration of Dr. Gogo Kensani and Gogo Dlamini in and of themselves. But secondly, then, the regulations and what they define as strict and rigid regulations in and of themselves. So with
Assist counsel, applicants seek to set aside the promulgation of the regulations by the minister. So the remedy should also speak to that. So my question will be then that can Section 6 address regulations that have already been promulgated by a minister?
Well, Justice, with respect to Section 6(1)(e), as I was making in my submissions prior to that, Endomeni encourages the courts to have a broad interpretation of particular provisions. In this provision, it's broadly stated, just to say the context and the language used within the Act, and it says any action or may consider any actions and make representation and take action in connection therewith. The understanding then of the respondent is that includes the remedy required or the remedy to uphold what the applicants may want in and of themselves with respect to the internal remedy. So with that broad approach then that was endorsed by Endumeni, that's how the
How does that address the question about procedural fairness and all of that? Because part of what they're saying is that the promulgation, it's not just about registration of the second letter. It's also that there are procedural issues with the promulgation itself. So how does Section 6(1) deal with concerns of procedural fairness and process leading up to the promulgation?
Well, Justice, to the extent that I understand the applicant's submissions, the contention with the procedural fairness aspect of this is the fact that they are of the view that HUM was not consulted sufficiently. Section 6(1)(e) provides for that remedy as well. Taking any action in connection therewith could look like extending roadshows again, continuing new roadshows to address these issues if HUM feels that that is the sufficient remedy in and of itself.
For regulations that are already gazetted.
Well, Justice, yes, we broadly understand it to mean that in and of themselves under the understanding of our interpretation with Endumeni in and of itself.
A separate point, I may be incorrect with this, but you correct me. Rely heavily on Endumeni. Endumeni deal with the interpretation of contractual provisions and not necessarily the interpretation of statute.
Well, Justice, Endumeni broadly deals with the principle of interpretation. It doesn't necessarily specify it within certain contexts. Similarly, then, the Concord has affirmed this in different cases in and of themselves. For example, in the airports competition versus the Big Five, Duty 5 free, paragraph 29, the courts affirmed that with respect to interpretation, there is no dispute about the principle of interpretation and outlined in Endumeni exists within those contexts, even on themselves. Continuing then.
Before you proceed from that point, maybe as a way to sum it up, I have submissions that process that the applicants could have engaged under Section 6. They have led to an instance where, if successful, promulgated regulations would have been set aside through the Section 6 process.
Well, Justice, with respect to that, I wouldn't want us to wander into hypotheticals because the applicants did not take that action and did not undertake Section 6(1)(e). So with respect to that, that is the furthest that the respondent can answer that question in and of himself.
Well, the applicants contend that they did not engage any of the provisions or any of the processes provided in that act because none of them constitute internal remedies. So it's not hypothetical. It stems from that. That's actually why the applicant. So the question is, if you're saying there was a process available to the applicants, which is under Section 6, the question is, would that process lead to an instance whereby the regulations, despite the fact that they have been promulgated in the actual law, they have been set aside through that process?
Well, just
been the remedy.
Well, Justice, to the extent that I do understand your question in and of themselves, Firstly, I would beg to differ to say the contention within the applicants in and of themselves is necessarily the fact that an internal remedy was insufficient. As far as their submissions go, their submission was that an internal remedy was unavailable, to which we have outlined section 61E, even if we were to read it in conjunction with section 27, which outlines certain appeals processes within the THPA. That already deals on the first leg of their argument. But secondly, the reason why I say we're going into hypotheticals is because the very sort of relief that could be granted or be used through section 61E was dependent then on when the internal remedy is exercised in and of themselves and for what purpose that exercise looks like. We don't, to the extent at which the applicants don't exercise section 61E either to either like make representations on behalf of Gokuk and Sanu, or particularly speak about striking down regulations, I feel then that we're striking into then hypotheticals. And on that regard, then we as the respondents are that is as far as we can take that matter in this court.
Council, apologies. I will simplify. Under section 6, what can an aggrieved party?
Well, Justice, the broadened statement within section 61E and the understanding of indemnity is that the council is empowered to take any action in connection therewith. So the respondents contend, even in that instance, that action could look like striking down, suspending, or amending certain provisions in and of themselves. So with respect to that and that understanding, that's the practical part of it then, Justice, if that answers your question. Justice, I see I'm running out of time. Could I request an additional 2 to 3 minutes just to wrap up my submissions?
You may, but I just want us to conclude on this point. You are now saying the council is capable of setting aside and giving the applicants the remedy that they have come to this court to seek. Is that what you've just said? You said the council could have set aside, amended, and all of that. Is that your submission? Just so that we conclude on this point.
Well, Justice, to the extent at which we understand the broadened understanding under indemnity of section 61E, we contend to that particularly. With respect then to the rest of our submissions in summary, respondents contend that internal remedies can be bypassed where exemptions exist. However, the court in Guayabe states, particularly in paragraph 42 to 46, that an applicant for exemption must demonstrate that the internal remedy is inadequate, unavailable, or that pursuing it would cause irreparable harm that cannot retrospectively be cured. With respect to the submissions made by the applicants before us today, the extent to which they make out the case of the exemption is one, that the internal remedy was unavailable, one in which we show you is available, but secondly then, that the reason why it would cause irreparable harm is because they could not find that internal remedy in and of themselves. Again, ties back conflating of the unavailability in and of themselves. With respect to the requirements set out then in Guayabe, the applicants don't have a leg to stand on. We've shown you the internal remedy. The respondents then submits then, Justice, that the consequence of non-exhaustion is that this court cannot hear the matter and the application is premature. The respondent submits, Chief Justice and Justices, that the exhaustion objection should be upheld. The application is premature. The proper course is for HUM to engage meaningfully with the administrative process before approaching the courts. Unless the court wishes to hear further from me, I'd now like to hand over to my co-counsel, Mr. Desi, to handle the point on non-joinder.
I want you to maybe indulge me on one last point.
Yes, Justice.
Part of what the papers on the facts say is that there was letters written to the minister and all of that. We have any, do you say that does not, so let's assume that we accept that section 6.1 is your internal position. But what do you say about the letters and all of the processes that were underwent? Was that?
Well, Justice, with that particular contentional point in and of themselves, one, the proper course was for HUM to address the council because the council is the advisory body to the minister. The Act even, the THPA even sets this out with section 47. This is to say the minister in consultation with the council. This is to say then they did not exhaust the administrative process properly. Them bypassing and sending a letter to the minister cannot be constituted to be an exhaustion of an internal remedy because the internal remedy wasn't for them to address a letter to the minister in the first place. So with respect to that, those are the submissions on the respondent. May it please the court.
Chief Justice, Justices of this Honorable Court, I'll address you for approximately 10 minutes on non-joinder, bearing in mind that we have 5 minutes floating. I arrived today wearing black sunglasses, not because I take a dim view of this court's wisdom, but because rather I require protection from the glaring inconsistencies in my learned friend's case. Let me make a few observations about the applicant's papers and the submissions they made before you today. We're ad idem with our learned friends that Amalgamated and Mieni are right authority for the proposition they make on the material non-joinder, the test for material non-joinder. However, where we differ is the application in their papers. Before you today, Justices, you have heard that Amalgamated comes from the SCA. It comes from the AD. It was handed down in 1949. You have heard that Mieni dealt with the non-joinder of the Minister of Finance. No, Mieni was an application to declare Ms. Mieni a delinquent. And Ms. Mieni raised a defense that she could not be joined alone in this application. She needed to be joined with the other directors. And that is found in paragraph 60 of your Mieni judgment. All that friends have referenced twice to this court the uniform rules of court. Might I mention to this court that the uniform rules of court apply to the High Court, and today we are before the Constitutional Court. Justices, our learned friends in paragraph 9, rely on the Langbeck municipality, the IEC versus Langbeck municipality judgment. That judgment did not concern non-joinder. What arose there was that Stillby had lodged an urgent application because IEC provided insufficient voting stations. Stillby won, they got a mobile voting station. The IEC, after the elections and complying fully with that order, went to the CC on appeal to appeal the matter. By the time Stillby had been subsumed into Langbeck municipality, there was no non-joinder in that case. In paragraph 8 of this judgment, the Constitutional Court substituted Langbeck as the respondent because Stillby no longer existed. Non-joinder was simply not an issue. In oral arguments today, Justices, you have been referenced a Kaunda judgment. That judgment, I may direct the court to what the prayers were in that judgment, to place that judgment in context. What occurred there is that the applicants wanted to declare that the government of the Republic of South Africa to take reasonable steps to extradite the applicants from the government of Zimbabwe and Equatorial Guinea. And in that case, there was simply no non-joinder issue. The matter was simply decided on its merit without reference to non-joinder. Justices, if I may move to the submissions I want to make before this court on this non-joinder point.
So, before you proceed, just a clarity. You are saying the case that they have reference, it's not applicable because of the prayers of the same judgment, because they are, and this is my understanding, they were not relying on the judgment, but the facts, the decision that was taken. I mean, the facts of the case, the application of the law there in that case, unless otherwise I'm lost in what they're trying to give us here.
Justice, reliance on Kaunda is misplaced because they say it support the propositions they advance in relation to material non-joinder. And the facts of this case, which was an extradition, it's an international law case dealing with extradition. It did not deal with any non-joiner. And if I'm wrong, the applicants may direct this court to a paragraph in this judgment which references non-joiner. The same thing will happen with Langbank. They will find no reference to non-joiner.
So what you are essentially saying is that they have incorrectly referenced cases that have nothing to do with their submission.
That is a bold submission I'm making, Chief Justice. Chief Justice, I now turn to my main submissions. Initiation is not merely a medical event. It is a rite of passage rooted in customary law. The presence of a traditional surgeon does not transform it into a purely health matter. It remains governed by custom, with oversight from the Minister of Cooperative Governance and Traditional Affairs. The same is true here. The Traditional Health Practitioners Act operates at the intersection of health and customary governance. To reduce it to a purely health issue fundamentally misunderstand its nature, just as initiation cannot be divorced from custom. This regulatory regime cannot be divorced from the structures that give that custom legal force. Accordingly, it is appropriate that both the Minister of Health and the Minister of COGTA must stand before this court. I will make 4 submissions, Justices. The first one, the applicant's case rests on the mischaracterization of the non-joinder test. They focus on who signs the regulations, rather than whether the order will prejudicially affect a party with a direct and substantial interest. And that is the wrong inquiry. Now, in non-joinder, in determining a non-joinder, this court only has to look at the relief that is sought, forget about the background of the case, and forget about any other ancillary issues that the applicants have put before you, but you focus on the order which you are asked to grant. The applicants asked this court to declare the regulations invalid and direct a fresh regulatory process that respects, with emphasis, living customary law. That order is not implementable without the Minister of COGTA at the table. The Minister of Health cannot, in isolation, give effect to living customary law without a department constitutionally and statutorily responsible for those communities and their leadership structures.
So the Act allows it in terms of Section 1. It defines quote-unquote minister as the Minister of Health. It's allowed in terms of the Act. The Minister of Health is allowed to take decisions, to make regulations. It's allowed in terms of the law.
Justice,
the applicant.
Justice, once again, let me remind you, the test is whether a party has a direct and substantial interest in the subject matter of the litigation. So when considering that, you may look at the provisions or at who signs the regulations. But that goes to the point that I've said in the beginning, that it focuses on the facts. And a test for non-joinder does not focus on the facts. It focuses what will happen in the future when you grant this order that is asked by the applicants.
Council, this court must also give effective, Section 172, effective, capable of being implementable order. So I hear your submission about the facts and all of that, but I like that you came to the practicalities of it. The applicants are saying this court must set aside the regulations and send them back, as you say, for a fresh regulatory process. If that happens, and as my brother says, the Minister of Health undertakes in terms of that process, what prejudice does the Minister of COGTA suffer with a decision that effectively says, Minister of Health, take a fresh regulatory process?
Justice,
I'm struggling to find out what prejudice will the Minister of COGTA suffer. As you say, this court is asked to send a process back to the Minister of Health. Is there any prejudice?
Justice, the applicants brought the application on a narrower remedy in terms of PACHA only. The Minister of Health would not have supported the non-joinder of the Minister of COGTA. But the problem is, the applicants, in addition to the PACHA ground, they challenge the violations of Section 30 and 31 of the Constitution, which relates to culture and custom. I've heard my learned friend trying to distance herself from their papers. But in their main heads of arguments in paragraph 33, they have an entire heading titled Constitutional Rights at Stake, and they only reference Section 30 and 31 of the Constitution. Saying justice that I only have a minute, and when I began, I said I have a floating 5 minutes. May I be indulged to use that 5 minutes? And so, Justice, the prejudice that the Minister of COGTA will suffer when you reach such a decision that directs a regulatory process that respects living customary law is that you will not reach that order without a determination on the violations of Section 30 and 31. And you can't reach those violations of Section 30 and 31 without the custodian of customs, traditions, and customary law in South Africa. And that is the precise submission we make.
I'm with you on that submission. Are you then not suggesting that both the Minister of Health, and this goes back to my brother's question earlier, that the Act itself empowers the Minister of Health to sign off on these regulations? By that analogy, are you then not suggesting that in the first instance, the Act in itself ought to be amended because it gives the powers only to the Minister of Health?
No, Justice.
You're not asking us to amend the Act then?
No, Justice. You don't need to amend the Act. If I may direct this court to the Traditional Health Practitioners Act, and in particular Section 6(2)(e). It expressly provides for consultation with relevant authorities. So the submission the respondents make is that the statutory regime anticipates a cooperative governance. This then becomes the dual oversight of this very same Act. And then for the applicants to now argue that the minister responsible for traditional leadership has no interest is, with respect, unsustainable. Lastly, let me point to this court that when this bill was considered, the Traditional Health Practitioners Bill was considered in Parliament, the state law advisors recommended that Parliament refer the bill to the National Houses of Traditional Leaders under Section 18(1)(a) of the Traditional Leadership Governance Framework because it implicates customary law. That alone demonstrates dual oversight. And Section 18(1)(a) is clear that whenever there's a bill that affects or pertains to customary law, customs, traditions, that bill must be referred to the National Houses of Traditional Leaders for them to make comments.
Can I want to go back to the issue of prejudice on those submissions that, so if we're with the applicant and we set aside the regulations, will the Minister of COGTA not still be able to participate through that process, that because it will be a fresh regulatory process? The minister, because that's how she was consulted from the get-go. She was consulted through that process that you're outlining. Will she not still be able to participate in that process? And therefore, is there any prejudice if we send it back so that she can, as you say, participate and deal with issues of customs?
Justice Kabapete, if you reach that conclusion strictly on the Paja ground, then the Minister of COGTA is not prejudiced. But if you extend the remedy you will grant to the applicants and you consider the alleged violations of Section 30 and 31, clearly you'll be entrenching on customary law, customs, and the Minister of COGTA remains the custodian of those two.
So, further to that, what specifically in the remedies sought by the applicants trigger that substantial interest from?
Justice, it is a constitutional challenge ground, one, that triggers the Minister of COGTA's interest. Secondly, we want you to direct a regulatory process that respects living customary law. The implementation of that regulatory process clearly would have or potentially affect the Minister of COGTA because the Minister of Health has no competency on issues of customary law. Justices, those concludes my submissions. And in conclusion, I'd like to also mentioned to this court that the applicant suggests that Cogta's absence implies a lack of interest. That submission cannot stand. One cannot rely on the silence from a party that was never served. It's common cause facts that the Minister of Cogta was never served. That is why the Minister of Cogta is not before you to plead his case.
Why not bring an intervention application?
Justice, my brief is limited to acting only for the Minister of Health and the Minister and the Council. I do not purport to act for the Minister of Cogta. And so I'm unable to give guidance to this court on why the Minister of Cogta has not brought an intervention application. In conclusions, the respondent submits that the point in limine of non-joinder must be upheld. The application is in any event premature for the failure to exhaust internal remedies. The application is also to be dismissed, and in the spirit of Biowatch, as the applicants assert constitutional rights, no adverse court orders should follow. Those are my submissions, if I may be of no further assistance to this court.
Council, I have one last question, please. If you go to paragraph 9 of your, and I know you.
My heads of arguments, Justice.
Of your heads.
Yes, Justice.
You say, therefore, any order affecting communities and customary institutions directly prejudices the Minister of Cogta, and that, therefore, what you say, any order affecting communities and customary institution directly prejudices the Minister of Cogta's competence and regulation, and that's part of why you say that the minister should be joined. The Minister of Cogta should be joined. When I read this, I read it to be suggesting that the Minister of Cogta should be cited in any matter that relates to customary institutions and customary communities. I just wanted to confirm, you still persist that the Minister of Cogta, by operation of law and by their competence, should always be cited when a matter comes before this court, and that matter is about traditional communities and traditional institutions.
No, Justice Kwabet. It may well be that our heads of arguments are not as elegant as our submissions today, but I would like this court to understand that submission in the context of the discussion I've had with the bench.
I accept.
Thank you, Chief Justice.
Greetings once again, my honorable justices and my court. My honorable justices, I have up to 6 points of rebuttals against the counsel for the respondent. Firstly, they relied on the fact that the outcome of the case of Kaunda does not suffice to strengthen our argument, and we submit that it was merely persuasive and we do not regard it as binding, honorable justices. Secondly, they stated that most of the cases that we did not use the correct information of the text, but as they allege, they should have provided before this honorable court the correct context and the correct paragraph that they allege before this honorable court, rather than merely relying on the fact that we did not use it, but they do not bring it as proof before this honorable court. As the Criminal Procedure Act requires that he who asserts must prove. My honorable justices.
Why are you invoking the Criminal Procedure Act?
Civil Procedure Act.
Civil, okay, yes.
Thirdly, my honorable justices, it is clear that the counsel for the respondent, it is not related to the fact.
Counsel, what section of that act?
172. Thank you, my honorable justices. To proceed, my honorable justices, it is clear that the counsel for the respondent is not familiar with the fact. The mere fact that regards the structure that made them think they have a direct and substantial interest was only the information that was involved in the letter that was sent to the Minister of Health. And they cannot still bring it before this honorable court because my other Lenin friend stated that they cannot be expected to respond because it was merely sent at the Minister of Health. The Minister of Health cannot adequately represent the distinct statutory structures of the traditional structures, my honorable justices. Lastly, my honorable justices.
Before you proceed, please could you restate that point? I'm struggling to understand.
Thank you, my honorable justices. My other Lenin friend who was addressing issue number 2 and 3 stated that they could not issue out a formal response the applicant, stating that it was only directed at the Minister of Health. But now the other co-counsel is now disputing it, stating that they now have a correct structure, they now have the correct standing for to bring the matter of a structure before this honorable court. But how did they do that if they did not they did not have the letter to them that triggers their cultural recognition of the structures? My honorable justices, the mere factor in, if it pleases the court, I would like to refer this court's attention to paragraph 23 of the facts. It is clear in that paragraph that the order, or rather the relief sought, was invalid regarding the validity of the Traditional Health Practitioners Act. It is nowhere in that paragraph they include the structures, or rather the provisions of the regulations of the structures, my honorable justices. The counsel for the respondent, in their heads of arguments, they say that the court can issue out a non-joinder merorutu. We submit before this honorable court that merorutu, my honorable justice, is a matter of necessity and not of inconvenience. For example, my honorable justices, I would like to draw this court's attention to the case of Amalgamated Engineering Union versus the Minister of Labor. In this case, the engineering union, the Amalgamated Engineering Union and its members had a dispute. And the Amalgamated Union decided to go to court to seek an order to appoint an arbiter for them. But the court was of the suspension that the other parties who had a direct and substantial interest had not been joined, which were the other employers. This can be regarded as a meromutu in cases where they have to bring a necessary party to this honorable court. My honorable justices, even if they raise a matter of merorutu, it still doesn't apply effectively because they still do not have a direct and substantial interest in the relief sought. They still
don't have a direct and substantial interest.
Yes, my honorable justice, they still do not demonstrate that prejudice before this honorable court. And we therefore respectfully submit before this honorable court that the counsel for the respondent is not related to the facts. They are merely relying on the facts that were included, that met the information that was included in the informal letter that was directed at the Minister of Health, of which they are still disputing because he said it did not reach to their attention. But our application before this honorable court is in regard with paragraph 23 of the set of law, which is regarding the validity of the section 47 of the Traditional Health Practitioners Act. And the question of law is not the same. The questions of law are not substantially the same, honorable justices. Our question of law is the validity of section 47, and their question of law is regarding the structures, and they are not the same. Taking this courts back to the rule 10, sub-rule 4 of the Uniform Code of the Rules, it says it only allows a non-joinder where the questions of law are substantially the same. In this matter before this honorable court, the questions of law are not substantially the same, and therefore we submit again before this honorable court. Failure to join them does not constitute a material non-joinder. If it pleases the court, my honorable justices, I would like to allow my co-counsel to proceed with the verdict.
How much time did you have for rebuttal?
We said 5 minutes of this time.
Just of your time.
Greetings once again, my honorable justices. I'd like to bring 1 point for rebuttal and another point for clarification under section 33. Based on the respondent's head of arguments, paragraph number 21, they do consent to this before this honorable court that the Healers United movement does have the prerequisite locus standi to institute this matter. If that's the case, then AUM should be given the locus standi as both the respondents and the applicant agree on the same issue. Further, my honorable justices, I would like to clarify on section 33. Section 33, section 33 was placed because it provides for the administrative rights of the citizens, as provided by the 15th paragraph of the set of facts. When the minister and the minister and the interim council were promulgating the 2024 regulations, they failed to involve or include the communities who lived in rural areas, and those are the people who are mostly affected by these regulations. As was stated by this honorable court in the case of Mohali versus Speaker of the National Assembly, the court invalidated the Traditional Health Practitioners Act because in this instance, the people whose rights were mostly affected by these regulations were not included. Thank you, my honorable justice.
Can I just check on that last point? just quickly. Your submissions, your written submissions say the violation would create standing. So I was clarifying that it's not the violation, they already have standing.
Greetings, my honorable justices, once again. I'm looking onto the time. I only have 1 point for rebuttals for the respondent. My honorable justices, the counsel for the respondent was emphasizing a matter of interpretation, but she fails to interpret the very same sections as she's stating that it deals with registrations of the traditional healers. And our issue here, and we are arguing that no provision that allows an aggrieved party to challenge an administrative action within that statute, there's no provision without that statute. So their argument on arguing on section 6, it is misplaced in this matter because that section only deals with registrations and does not have an effect or direct or does not address the relief sought in this matter. Even if we can take the remedy that they are stating, my honorable justices, and test it according to the test that was stated in Koyabe, the case of Koyabe versus Minister of Home Affairs, the remedy is ineffective, the remedy is inadequate, and it's also unavailable. So their argument is misplaced, is misleading this honorable court. And if it pleases the court, I'd like to own my seat.
Judgment will be reserved. Court adjourns.
All rise. Court adjourns.
Brother.
Can we deliberate as, on the.
Sorry, one more.
Counsel, excellent job.
Thank you. I hope I see that.
Procedure stuff.
Yeah.
Let me just ask Cecily and Joseph.
Yeah.